In this video, we will reveal how to prevent fair lowball settlements using an interactive tool that will assemble all the case records to include medical, administrative, legal, and economic decision points that insurance companies use to determine settlement value. You will see for yourself how this is saving 50% of the time to produce a demand package and how it is used to eliminate varying opinions. We'll also reveal a process being used nationwide by plaintiff attorneys to win the greater weight of the evidence challenges. To begin, log on to our site at Liberator2.com. Once you're at the site, click on Attorneys and click on Attorney Database Login. Plug in your user ID and your password to log into the system. Keep in mind, you don't have a user ID or password at this time. Now, we've gone to the full screen, so it's time to either find a client or add a new client. They're both the same, so what we'll do is I created a file for you, so let's go to find a client. To find a client, click on find a client, and then just click in their name, type in their name. The client that I'm going to use here is called Sample Client. And it will pull up. Click on that once it pulls up. Type in the patient's name. It will appear. Click on that name, and then click Find, and it will find that particular client for you. Now you see the section here that says Access Demand Letter. Just click Access Demand Letter. Now we've created this file to make it a little bit easier for you to see what would be required of you and your staff. This is the Finalizing Claim Settlement Demand Introduction. Contains all the data you'll need. Example, what it's in regard to, settlement demand, the client, the claim number, the claims adjuster's name, the date of the loss, date of the request. Your actual demand will be listed there. In this case, we're asking for $68,000. The date the response is due, we usually go out 40 days. Now, next comes introductory language, and I want to point out to you this entire document has been created in a Word document format so you can make any changes that you want. We have included sample languages that we've assessed from thousands of demand letters nationwide, which you can use and by accessing the library or create your own language or combine them, all for your convenience and all contributed by other plaintiff attorneys to help things go right for us. This one just says our firm has the pleasure of representing. You'll see it says Sample Client. That's the name of our client. And you'll see here the name of the claims adjuster has been automatically populated. So this will auto-populate. The negotiation initiated by this demand package is for a bodily injury settlement. We're submitting this information solely for purposes of giving your company a limited opportunity to offer to resolve this claim, so on and so forth. All right, let's move on. And so again, that is in a Word document, and you'll have full access to edit, use your own language, or review some of the sample languages that we've acquired and morph them into your own viewpoints. Now, regarding the medical history, if you're going to look at medical office records, you click Reviewed, and then if you're going to enclose them in your demand package, you can click the button to enclose them. Look at hospital records. Look at records from other source, perhaps witnesses, police reports, ambulance reports, emergency room records, records from other physicians, records from the clients. If you're going to review them, click Review and then click Enclose if you're going to add them as exhibits to your case. If there's a delay in seeking care of more than 14 days, it needs to be adequately explained. If that's the case, our software will offer you language to use to help you get through that obstacle. In some states, you can't even sue if you wait more than 14 days. Same thing with gaps in treatments. So if there is a gap in treatment, you have to take a look at why and use certain language to explain it, or it'll devalue the case if they even accept the case. When it comes to the clinical evaluation, we find that you probably want to look at the physical exam, the injuries, and they should be listed by ICD codes. Look at the symptoms that were documented, any other tests, lab tests, special tests, diagnostic procedures, specialty evaluations, or medical validation. Simply click what you're reviewing and click what you're enclosing. What you don't click won't be printed. Now you get to click Skip to the Liability section. When you click on that, it takes you right to the administrative, the economic, and the legal factors of the claim. This does not cover the medical components yet. Stay with us. So in the liability, this is a lawyer input field. Again, this is in a Word format, so you can add as much, delete, subtract, use whatever language you like, or look at our library of languages and maybe borrow some suggested language. But this is simply for liability, who was at fault. There are some sections here that you can check or not check to include, we find that a majority of our attorneys have used this language, like this language, prefer this language to be included, so we made it pre-printed for you. You can just click on it to include it or leave it blank and it won't print. And the next field is for property damage, which would include the vehicle, photos if you've taken any vehicles, or anything else that you want to show the significant impact between vehicles or resulting property damages. Then we come to current expenses and losses. And this is for current treatment, any current labs, diagnostics, current medical costs, other medical costs. Then we talk about the loss of the vehicle or the car rental costs, additional property losses or costs, current economic expenses, current income losses, and then the total current economic expenses and losses. Now, if you don't want to enter any of these fields, leave it blank. It won't print. Okay, it's also, again, in a Word format, so you can edit it at any time. This is the mileage cost for mileage drivers, indicating the number of miles client has been required to drive in order to meet the appointments as a result of the accident. So, how many miles did he drive back and forth to the physician's office, attorney's office, hospital therapies, labs, auto body shop, valued at 52 cents per mile if you use mileage drivers, and if you don't, leave it blank and it won't print. Now, this section here deals with future medical costs. A good part about this is our software will automatically populate the future medical costs from the doctor's medical file. And it will also include the current costs and the future costs. So those fields will auto-populate for you. Another thing is we actually look and review and scrub the future medical recommendations to make sure that they meet criteria and protocol to win the greater weight and to establish the preponderance so that those factors are accurate. And then it continues along here with estimated future treatment costs or expenses for therapies, labs, other medical costs, total future costs for you to plug in the values that you feel are documentable and recordable. Future economic expenses and losses for vehicle, car, rental expenses into the future, or other economic expenses or losses, and the totals of them. And then all the total costs, current and future. Again, this is information that has been derived and been volunteered and gifted to us from attorneys nationwide over the past 3 years, and this is what they seem to document for the most part. But again, if you leave it blank, it won't print. And then there's the evidentiary conclusion, and this comes from the medical portion, which will be populated for you. Those buttons will be clicked for you. Those check marks will be there for you if the medical doctor has entered that value into his field, which we'll explain to you in just a little bit. And now it comes down for the settlement demand itself. Now, I'm going to read this because I think it's important. This was the best language we've had that seems to have the greatest impact. It says, based on the liability, impact, well-documented objective medical findings, which are inclusive of injuries, diagnoses, complaints by intensity, frequency, type, and radiation, further effects on the individual, including the documented permanent impact, the effect on the client's loss of enjoyment of life, duties under duress, and given consideration to the treatment, the plan, the prescriptions, the recommendations, the stability of the condition, the prognosis, future treatment, current and future medical costs, economic losses, MMI, percentage of whole person impairment, and total monetary factors. Please indicate your willingness to offer to tender, and there's a dollar amount in there which our computers will suggest to you for the medical value of the case only. So please indicate your willingness to offer to tender $68,610 of your insured's policy limits by forwarding a release and settlement check made payable to your firm will be populated there and on or before a date which we suggest is 40 days out. And this language over here has had the greatest effect, has been the most successful among the attorneys that have been using this in our 3-year beta studies, and so we leave it here for you. Again, I want you to understand it's in words so you can use any language you want. Now, when I say this dollar amount for medicals will be suggested to you, you do not have to subscribe to these suggestions, but there are 3 formulas that can be used to determine what medical care should be valued at, including the future care. And so we make that calculation automatically for you based upon the medical information submitted, and then we'll give you this suggested dollar amount. To it, you add any administrative, any legal, and economic costs that we're not familiar with. But these are just the medicals. So you add vehicle damages, rental costs, so on and so forth. All right. I think that'll work. Oh, shit! Okay, now we got to go to produce the demand.
Okay, let's do
so
that.
Leave it right there.
Let's do that then. So we keep recording forward. And,
yeah.
All right. So then we will save this information.
Okay. So is it recording now?
Yes, it's still recording.
Oh, okay. All right. Well, all right. No, just want to go to the end. You're going to have to edit that.
Yeah, we can take a.
All right.
Take
I'll say start here. Hold on. Okay. All right. Edit and start here. Now we're at the final section, which is the demand for settlement. I've explained to you that we've made a suggestion for a dollar amount, which is a medical factors only. Now, to print this, click on the button on the bottom. It says Save and Generate Finalizing Claim Demand Letter. Click it, it'll save it, and it'll print the actual demand letter for you. You can easily say it says document has been generated. Click here to access it. And here comes the demand letter itself. This particular demand letter, as you can see, is, let's see how many pages this one is. Will it tell us? Well, we'll find out in just a minute. The top part here is left for your letterhead. You could either add your letterhead into this once you've got the software, or print it on your letterhead. We'll show you in a video a little bit later how to add your letterhead or give room or space to print onto your existing letterhead. But this is a sample of what the final claim settlement demand letter will look like. Okay. Now, we showed you before medical history, reviewed or enclosed, clinical evaluation, reviewed or enclosed. Now you'll notice the sections here deal with the medical file. Now stay with us because I want to show you some good news. You'll be able to send your medical doctor a simple form electronically by email asking him to fill it out, which, when he does, will automatically be transposed into your demand letter, just as it appears here. So you don't need a narrative report, you don't need the medical file, you simply send an electronic form to your medical doctor telling him you're about ready to settle the claim and you'd like him to please fill out a few questions which will be processed by our software, translated into an injury model and an impairment model, and it'll be put right into your demand letter using the correct language, in the correct format, in the correct sequence, and it'll look like this: diagnoses, and it will list them all. Sections on radiculopathy, which are extremely important. Sections on spinal compression tests. Again, these are all from AMA guides. It's very imperative that all the medical decision points are listed. So if your doctors will use our form, which you can send them, our software will transpose their information into an injury model and an impairment report, listing every body, part, organ, function, system, and referring it to the appropriate guides in an effort to win the greater weight. This is what it looks like. And it gives a full impairment rating automatically. This section here shows all the complaints that the patient had, by intensity, by frequency, by duration, by further effects. Then it comes to the duties under duress. If you're not using duties under duress, they're valued at 25% of the medical claim. I'll show you in a minute how you're going to be able to send duties under duress to your clients for them to fill out. Click a button and it will automatically populate into your demand. Another section called loss of enjoyment, to factors that patients suffer that interfere with the functioning of them and their enjoyment of life and their performance of duties under duress, needs to be included into this. These are decision points that translate into value. So you'll be able to email your patient a form to fill out duties under duress, loss of enjoyment. They can click it. It comes back, populating into the demand letter in the right language format and in the right sequence. Then we'll continue to list the treatment, stability of the medical condition, the medical determination of future treatment, the overall prognosis, the prognosis for each body part, the future treatment plan, and then the MMI for each body part and an overall MMI, then an impairment rating. And if you have multiple doctors, so you've got a pain manager, an ortho, a neuro, a chiropractor, all of their evidence and all of their recordings and all their documentation will automatically transpose and translate into an impairment rating and populate into your demand letter with the correct language, format, sequence in order to interface with the insurance company. And then finally, the whole body impairment. Now it comes up to your components: liability, property damage, current expenses and losses, mileage costs, future medical costs, future economic expenses and losses, all total costs, current and future, the evidentiary conclusions, the final demand for the settlement. This was a 17-page demand letter with your letterhead all ready to go for you. You've got administrative, economic, and legal decision points that will convert into a settlement dollar amount. a formula used by the insurance companies actually called the point to dollar translation percentage multiplier. So it takes the decision points and translates them into a dollar amount based on each insurer's rate and formula. When the decision points are missing, the settlement valuation is missing, and that results in unfair, unrealistic, lowball settlements. It's the objective here now for you to capture all those decision points. Now, we haven't had enough time to explain to you all of the medical decision points, but I can tell you how we've made it easy. If you click here under your sample client, come down to the section where it says Request Additional Medical Expert Report, I'm going to show you what makes this so unique. Now, you click that, and all you have to do is enter the email address right in there of your doctors, as many as you've got. It could be different disciplines of doctors, and then you just click on the button at the end. Hold on, let me scroll down. Having a little trouble with this mouse right now. Click on that button to send that message, and this is the report that you will see. Okay, you'll see the medical expert report. It comes with a note from you explaining to the doctor that you're ready to go to settlement demand. Okay, there's the note. Dear doctor, I am representing my client, your patient, and the name of the patient, and the case has progressed to the point where I am ready to settle. I respectfully ask you to provide the following brief information regarding this case so I may settle the claim at this time. This is not a request for a full narrative. Please simply click on the link below and fill out the brief patient data report form directly online and then send to me. And then this is the form they will receive. Just got to put their name and their address, patient's name, and answer these few questions. Now, here's what the good part is. I don't think any of them are going to object to answering these questions. But those are the questions that make up the medical decision points. When they're done, all I've got to do is click here to save, and it will automatically send that information to you. But our software will translate it into an impairment rating examination. It will list every body part, system, function, organ involved. It will list the loss of functioning according to the International Classification of Functioning. It will list the impairment ratings. It will use either the 4th, 5th, or 6th edition guides, depending upon the nature of the condition and the state that you're in. It will include the diagnostic-related estimates, the diagnostic-based injuries, the specific disorders of the spine impairment summary, the whole person impairment, the regional impairment, and it will list the tables and chapters of the guides that were used. This is how we are establishing the preponderance. And we'll do this, the software will do this automatically if your doctor will just fill out this data form. Here's the bad news. If he doesn't fill out this form, I don't see how it's possible for you to take all that medical information and transpose it into an impairment rating report where the decision points are derived from. Now, here's the reality. We've reviewed countless numbers of demand letters, and we found 80% of the decision points are missing. Most of the missing decision points are the medical decision point. By having your doctors fill out this simple form electronically and then clicking it to send back to you, our software will transpose it and put it right into the demand letter, transposed into the impairment rating, listing all body parts, system functions, organs, tables and chapters and pages of AMA guide to establish preponderance, all automatically for you. And that's how we are establishing the preponderance and adding value to the claim. This is our website, Demands at Command. We are assuming that you've already watched this video. Therefore, you realize 80% of the decision points are missing in most claims. And we're here to prevent that. The insurance companies have actually created this system in the mid-2000s. And if you've looked at the video or you've perused this website, you'll know that there are 14,000 value drivers, 27,000 severity drivers, 33 liability drivers, 15 additional increase multipliers, 26,000 standard multipliers. These are all factors that derive settlement valuation. And then they use a point to dollar translation percentage multiplier, and each insurance company's got their own rate and formula to take those decision points, those value drivers, and translate them into dollar amounts. So I wanted to point out to you that these are the decision points that you should have in your demand. The ones in blue are medical. I think if you compare these to what you're getting now in your medical documentation, you'll see that there's missing decision points. The entire purpose of using our software and sending your doctor that special request form to fill out is so that the software can include all of those decision point factors in the right language, put them in the right format and in the right sequence into your demand all automatically. Can you imagine the time savings in this? And can you imagine the increased valuation of the case? So feel free to peruse the website if you haven't already. And by all means, look at the video that is started on that page. And that's a synopsis of how the insurance companies are able to make unfair, lowball settlements and get away with it, even though those are unfair claims practice acts. Now you have an opportunity to email your patients the duties under duress form and loss of enjoyment form by clicking this icon right here. Simply add your client's email address in this section. Scroll down and click to send the message, and your client will receive the duties under duress loss of enjoyment form. That form actually looks like this. We've been working with doctors and attorneys now for 3 years, and most doctors asked us if we could create an input form for their patients to log in their complaints. So we created a form here that makes it possible for the patient to read, enter, and document any of the complaints that you would or could expect in a low-speed motor vehicular accident. Nothing here has been eliminated. So the actual patient and the actual client themselves will have an opportunity to read and review all of this and get a chance to click off what their complaints are. The significance to that is that it will cover all the possible body areas that could be involved in an accident. Therefore, we're not going to be missing any of those medical decision points. It will peruse mild traumatic brain injuries, closed head injuries, everything related to the connective tissue, the fibers, the muscles, the discs, the nerves, the bones. Nothing is omitted. Now it comes to duties under duress. This is when the injured party has difficulty with work duties or domestic duties. Work duties, domestic duties inside the home, household duties outside the home, even educational studies in school. If they perform any of these activities while in pain or pain interferes with activities, they should check it off. These are what the insurance companies consider factors and decision point factors that will translate into a settlement dollar amount. They do the same thing for loss of enjoyment. If you've seen the new AARP insurance offered through, I think, Northwestern, you'll actually see. You mean if I can't walk my dog, you'll send somebody to my house to walk my dog? Yes, loss of pet care, not able to take the dog out, not being able to drive the family to and back and forth from school, loss of exterior landscaping, interior cleaning, decorating. Whatever these are, they have a value from the insurance company, and they should be documented by your patient, by your client and the patient. So you'll be able to mail it to them by email, and once they click and save the data, it comes directly into your demand letter in the correct language, in the correct format, and in the correct sequence to interface with the insurance company. It is suggested that 25% of the medical claim is attributed to duties under duress, 25% of the medical claim is attributed to loss of enjoyment of life, 25% of the medical claim is attributed to the actual injury types, and 25% of the medical claim is attributed to the whole person impairment. To those factors, we use a formula, one of 3 formulas, to derive a settlement value. To that, we add the future medical care and costs, and to that, you add the administrative, legal, and liability factors. So we help you to arrive at a very fair settlement value. And you'll see at the end here, you can save and generate the finalizing claim demand letter. So this information will go right back into your demand letter. We hope that you have perused our webpage called Demands at Command and clicked on the peer testimonials. But the point is, while we've had tremendous success with this, on occasion, and a rare occasion, the insurance company, industry, or adjusters can engage in an unfair claims practice which has been cited as tuning bias. And you can check out the references on our websites, and you can see where the CNN, the Consumer Federation of America, the National Association of Insurance Commissioners have conducted major and extensive investigations and found that the insurance companies have a way to tune down or dial down the value of the claim by just clicking a button in their software. It's called tuning bias. This is an unfair claims practice act. When we find that the insurance companies refuse to give us the value for the value drivers that we submit to them in the correct format, sequence, and language, then we do what we call a rebuttal discovery. How would you like to know what factors of the claim the insurance company accepted as causally related to the claim, what factors the insurance company denied, what factors they disputed, and what factors they might accept additional information for? So what we've done is we've created an electronic form that we send to the insurance company. And for example, let's read this. For this section, please indicate by check marks which factors you causally accept as related to the accident, which factors you deny, which you dispute, and what additional data you require to consider. And then we go through here. This one goes through some of the complaints. We said there was a post-traumatic headache. Do you accept it as causally related? Deny it, dispute it. What data do you need to reconsider it? So in this case, we're doing this for the diagnoses or the complaints. For every factor, every section of this claim, we're asking the insurance company to explain what did they causally accept as related to the accident. Here's the factors for duties under duress. Individual factors that comprise duties under duress are experienced by the patient, and they were submitted to you as having been suffered as a result of the injury types. These constitute value drivers that should be included in the value of the claim and enhance its value. Please explain which duties under duress you accept as causally related to the accident in question, and which, if any, you dispute or deny, or what data you need to reconsider as follows. So for every factor of the claim, for the diagnoses, for the treatment, for the medical expenses, for future medical care, for prescriptions, for immobilization devices, for referrals, for therapies, for the need for future care, for the stability of the condition, for the determination of the need for medical care in the future, for the prognosis of each body part, for the prognosis overall, for the MMI of each body part, for the MMI overall, for the future treatment plan. For every factor of this case, please explain which factors you believe are causally accepted, which you deny, which you dispute, and what data you need to further reconsider. What this will do, basically, and by the way, we'll show you the way to have the insurance companies answer these within a 40-day period. It's our understanding that this is a first-party claim. We'll go up to the language in the beginning of the document, and where it explains why we're making this request. So let's just take a look at some of this very briefly. It's unclear to us as to the rationale you used in determining this low settlement. My client is therefore seeking an explanation of how you arrived at this $2,000 offer, since we asked you to pay $68,000, whatever. Since you did not adequately inform us of the reason you made such an unfair, unrealistic low settlement offer, this causes my client concern that perhaps you did not give his claim full, thorough consideration, of which he's seeking an explanation from me. Now, by the way, my client has asked me to take further action as applicable to determine fairness of the claim settlement practices engaged. My purpose is to renegotiate the offer and settle this claim for a fair, equitable, and reasonable offer. This is the reason I am contacting you for your reconsideration, as my client is questioning me regards whether, and whatever insurance carrier name is, it will automatically populate the field, whether your blank insurance company is honoring the covenant or terms of the contract based on your judgment in offering a low payment for this claim. I'm in a precarious position, as I'm not able myself to understand, or therefore explain to my client how you arrived at the settlement value of whatever it was low. Therefore, I respectfully ask you to explain how you evaluated this demand, including what factors you based your offer upon. The language here is extremely good language. Now, we're going to bring in the codes of ethics of an adjuster so that they know that we're aware of them. We can do this even by state. But it tells us that when an insurer denies or rejects a first-party claim in whole or in part, it shall do it in writing and provide to the claimant a statement listing all bases for the rejection or denial and the factual and legal basis for each reason given for such rejection or denial, which is then within the insurer's knowledge. So you're entitled in a first-party claim Now, if your client will sign over power of attorney to you, or if the client will sign these documents himself, they can make a first-party claim against their insurance company, and so our understanding within 40 days they'll have to provide you all the factors that they use to arrive at that settlement value. Basically, what this is going to, including low-speed impacts. So if you've heard there's no visible property damage, so you're not injured, if you've heard there were prior accidents or pre-existing conditions, if injuries are not easy to see with the naked eye, if evaluators don't agree on the injury types, or if evaluators don't agree on the degree of impairments, our software is going to help you to eliminate those litigation obstacles. This demand letter can be up to 30 pages long. By a click of a button, it will produce it for you and pull out all the specific areas of your particular client. You don't have to even dictate a word. Just click the button and the software produces for you. Hopefully, you will not have the need for this rebuttal, because using our software initially will establish the decision points that value the case and will prompt the insurance companies and the adjusters and their softwares to pay the value of the claim that the decision factors were entered into. So there's a lot that we can do for you that I can't explain in this brief tutorial, because I know how valuable your time is, and you're looking at this now because you have considerations. So I would like to say this to you. I've pointed out the benefits and I pointed out the features in a brief format. You're entitled to, and we will give you tremendous additional information, and we maintain a growing library online, and they are specific for all factors of the medical, administrative, legal, and economic parts of a claim. But I would like to point this out to you. If you're undecided now, I think you need to take a look at what's going to happen if you don't step up to a new way. The insurance companies hired consultants to change the way they process claims. It's called business process improvement. They also created core claim process redesign. Listen to the name. They went right to the core of how they process claims and redesign them. So what you've been using for years and years and years doesn't apply anymore. Duties under duress, loss of enjoyment, all of the decision points of value drivers. There are now 67,000 different varieties of them. Majority we have found in the last 3 years to be missing, and that's why we've put this together. So I don't know what's going to happen to you if you continue to do things, but I can tell you that I don't think it's going to get better. I think it's going to get worse. I think the demand has to be not just on the insurance company, but I think it has to be on you too to find a new way to do business, and that's what we offer. You're invited now to try this. It's a month-to-month basis. Click on the agreement for the free software use. Read and review the agreement. If you accept it, you can get on a trial program to this, and let us help you to prevent unfair settlements. Remember, we're not the enemies here. We're here to help. Thank you for viewing.